Hello there, I'm attorney Kelly Longtin from Kelly Longtin Law, and today I want to talk to you about life insurance and estate planning and how you can protect your beneficiaries' interests. Now, a common misconception people have about life insurance is that they only need to designate their spouse or their child or their loved one as the beneficiary of the policy to ensure that the life insurance benefits will be available to the beneficiary when they die. Life insurance is an important financial and estate planning tool, but without certain protections in place, there's no guarantee that your beneficiary will receive or keep the benefit from that insurance policy. So let's look at what I'm talking about. So I just want to go over a couple of examples with you. So first is Dave has a wife named Betsy. And he's named his wife Betsy as the beneficiary of his life insurance policy. And then at David's death, Betsy does in fact receive the death benefit from the insurance policy. But when Betsy remarries, she adds her new husband's name as a joint owner of the bank account where she deposited those proceeds from the death benefit. In so doing, she inadvertently leaves the entire death benefit from David's life insurance to her new husband instead of to the children that she and David shared. And this is what they had discussed they wanted to have happen before he passed away, and exactly how he indicated in his will and then in her will as well. So let's look at another example where things can kind of go awry when it comes to life insurance. Here we have Dawn. She's a single mom, and she named her 10-year-old son, Mark, as a beneficiary of her life insurance. She passes away when he's 12 years old. Now, the court names a relative as a guardian, sometimes referred to as conservator, for Mark until he is legally an adult. By the time Mark reaches his 18th birthday, his inheritance has been partially spent on court costs, attorney's fees, and guardian's fees. In addition, its value has not kept pace with inflation because of the restricted investment options available to guardians. Dawn has hoped that the life insurance proceeds would be available to pay for Mark's college expenses, but because of the cost and the lack of investment flexibility, there's less money available to Mark. Now, Mark receives the remaining funds, spends them frivolously, and within a year or two, literally has nothing left. Now, you can all name a trust as a beneficiary of your life insurance. And this is a common method for leaving money and property to loved ones in an estate plan is by titling assets so they are owned by the trust or making the trust the beneficiary of the account or the property with the spouse or child as the trust beneficiaries. The same approach can also be used for life insurance policy proceeds. Two popular ways to achieve this result are naming a revocable living trust as a beneficiary and also setting up an irrevocable life insurance trust. Let's first talk about revocable living trusts. For individuals with accounts and property valued below the current lifetime estate tax exemption amount or who have already set up a trust, naming a revocable living trust as the beneficiary of a life insurance policy can be a useful option. Doing so simply adds the death benefit from the life insurance policy to what you already have in the trust, payable only to the trust beneficiaries according to the instructions already in the trust agreement. The benefit of this approach is that it instantly coordinates your life insurance proceeds with the rest of your estate plan. So let's talk about irrevocable life insurance trust. An irrevocable life insurance trust is an added layer of protection because it can both own life insurance policies and be named as the beneficiary. You can create an irrevocable life insurance trust either by transferring ownership of an existing policy into the trust or by the trust purchasing a new policy. Using your annual gift tax exclusion, you can make cash gifts to the trust to pay the insurance premiums. And then upon your death, the trust receives the death benefit, and the trustee distributes the money according to the instructions in the trust document. This strategy also allows you to remove the value of the life insurance policy, and the death benefit from your taxable estate. Now, despite the estate tax exemption currently being at a historic high, it is likely that the exemption amount will change under the current administration or sunset in 2026 at the latest. Therefore, if you've purchased life insurance, consider taking the extra step to ensure that your loved one's financial futures are secure. To discuss your best options for structuring your life insurance estate plans, just give us a call, and we're always here to help you with these things. So my name is Attorney Kelly Longtin, and I'm the founder of Kelly Longtin Law, where we provide effective estate planning for everyday families. So I hope you found this video to be helpful. Please like or subscribe to us below, and make sure you check out the rest of the videos that we have on our website, kellylongtinlaw.com.